Greetings, everyone. Professor Steve Scooter from the George Washington University Law School. We're so pleased you all could join us today. In just a moment, I'll turn to our speaker, but a quick administrative note. When the presentation actually starts, please use the chat box to indicate if you have any questions you would like to ask. You can simply type the letter Q into the chat box or indicate that you have a question. Professor Eukins will be moderating that and will call on you in order after the presentation. It is now my unique privilege and honor to introduce one of our colleagues for this morning. We have with us today visiting Associate Professor Victoria Christoff. I'm sure that most of you are familiar with her at this point or her biography, but in addition to being an alumna of the school and an experienced practitioner at the law firm of Morgan Lewis, she clerked for both Judge Marion Horn on the United States Court of Federal Claims and Jimmy Reyna on the Court of Appeals for the Federal Circuit. And without any further ado, I will turn it over to her. She'll briefly discuss her paper. We'll open it up for questions. And again, thanks for joining us.
Thank you, Steve, for that introduction, and thank you all who are joining us online or in person. I'm pleased to be sharing this presentation of my draft paper, the title, "The Ball is in Their Court: How Courts Can Provide a Clear Path for Protests of Prototype OT Agreements by Clarifying in Connection with Under the Tucker Act." Put simply, there is an undecided jurisdictional issue concerning in which forum should protests of prototype agreements be filed: the Court of Federal Claims under the Tucker Act, or in district court under the APA, Administrative Procedure Act. So the goal of this paper is to hopefully provide a way forward for courts to address this issue and hopefully fix it. So, but before I get started, I wanted to make two preliminary points. First, I'm working under two assumptions here. The first assumption is that protests, which are challenges to the award process of a government contract, they're a good thing, and that we need them in the OT environment, OT other transaction agreement environment. And the second is that we are now past the threshold of whether these types of protests for this particular type of agreement can be filed in federal court. It's now a question of which court. So with those working assumptions, I will go ahead and get started. So today, yes, this is going to be a high-level overview of my paper, brief keyword, hopefully. I'll be talking about some background principles, and I'll get into the discussion, the analysis part of my paper where I present a recommendation, and then would love to hear some questions from you all. So in terms of background, it's going to be important to understand what a prototype OT agreement is, the Tucker Act's in connection with requirement, which, as my paper puts forth, this is the key to understanding where these protests need to be filed, and then the three trial court cases that have looked at this issue. So a prototype OT agreement. First off, what is an OT agreement in general? An OT agreement stands for an other transaction agreement, and by statute, it's a transaction other than a contract, cooperative agreement, or grant. One thing should be clear, though, despite this generally broad definition, is that these are binding federal contracts, and they're different types. Different agencies have different statutory authority to enter into OT agreements. Some can enter into them for research purposes, others for prototype purposes, some even for more specific purposes. Here in this paper, we're looking at a particular type that the Department of Defense has the authority for, which is a prototype OT agreement. These types of agreements must, by statute, be directly relevant to the DoD's mission. And while the statute is pretty broad in terms of the contracting process, the DoD does not have unfettered discretion when entering these types of agreements. The statute requires the agency to engage in competitive procedures when making these awards to the maximum extent practicable. And to just back up, a prototype is It is not the final product. It is a working product that the government is testing to see if it's viable for future production purposes. So, as I mentioned earlier, protests of these prototype agreements are coming through the trial courts, but we're not getting the clarity that we need as to which forum they belong in. And the two forums available are the United States Court of Federal Claims or the District Court. I believe, based on Federal Circuit precedents, so binding to courts within the circuit, that the answer turns on three key words in the Tucker Act in connection with. Under Section 1491B1 of the Tucker Act, which provides the Court of Federal Claims with exclusive jurisdiction over bid protests, certain objections are allowed, and these objections have to be in connection with the procurement or proposed procurement. The objections are objecting to solicitation by a federal agency for bids or proposals for a proposed contract, a proposed award, an award of a contract, or an alleged violation of statute or regulation. Key here, all of these types of objections need to be in connection with the procurement. Now, below I've listed this case, Resource Conservation Group. It's a case that was put out by the Federal Circuit about, I believe, almost 10 years ago. In that case, the court clarified that this in connection with requirement attaches to all of these types of objections. There's an asterisk by it because the validity of this case is questionable, given intervening Supreme Court precedent, which affirms the importance of the last antecedent rule, which requires or provides, that any modifying clause at the end of a list modifies only the clause preceding it. So in this case, the in connection with would only attach to an alleged violation of statute or regulation. Whether this case gets overturned and what the effect that's going to have on Tucker Act jurisdiction remains unknown. The assumption here is that this is still good law. It is. It hasn't been taken en banc yet. So we're working under the assumption that this is the law today. So turning to these three trial court cases, some of people in this area of law might know these cases by now. The first one was filed in 2019 at the Court of Federal Claims, SpaceX versus United States. And in that case, the prototype agreement was part of a multi-phase program put out by the Air Force to procure, at the end of the day, space launch services. So phase one were the prototype OT agreements, phase two were the procurement contracts. SpaceX did not win an OT agreement, brought a protest. The court said that there was no Tucker Act jurisdiction because the prototype OT agreement was not sufficiently connected to the procurement or proposed procurement. Instead of articulating a standard for helping litigants understand when this type of agreement is officially connected to procurement, the court just listed various facts. And based on these facts, found that there was not a sufficient connection. Interesting, I found it, that the court noted that this was a close call, that the prototype OT agreement was related to the procurement, but in some sense still not sufficiently connected, even though all parties knew that these prototype OT agreements that were awarded to develop launch services that would be bid down the road. And despite the substantial funding the Air Force gave to the winners of these agreements to help them develop their products to be bid down the road. I mean, substantial, 500 million to almost $1 billion. So the takeaway for litigants from this case is, one, only prototype OT agreements that are very closely related to a procurement would fall within the Court of Federal Claims jurisdiction. And the more facts that you can allege to show this, the better. The second case that came was MD Helicopters. And in this case, it was first filed in district court. The district court found that it did not have jurisdiction, but rather the Court of Federal Claims was the proper forum because this prototype OT agreement was sufficiently connected to a a procurement. Here, this agreement aimed to create prototypes of a specific type of helicopter that the Army wanted to procure down the road. And the court found that there was a sufficient connection because you had to essentially win the prototype OT agreement in order to be considered for a procurement contract. And then the last one is Kinemetrics. This one was filed in 2021 at the Court of Federal Claims. In this case, the court found that the Tucker Act did have jurisdiction over the competition. It's important to note, though, that there was no prototype agreement actually issued. At the end of the day, the agency issued a traditional procurement contract. But the court made some interesting points in passing, that protests that are directly related to a procurement are within the Court of Federal Claims jurisdiction, and protests that have no connection are not. So essentially provided guideposts, goalposts to the outer limits of Court of Federal Claims jurisdiction for bid protests, but didn't really address what happens to protests that have some less than direct connection. So where are we now? There is some confusion about this dividing line. When is a protest sufficiently connected to procurement? We know that if a court finds a sufficient connection, it's likely going to allow the protest to stay within the Court of Federal Claims. If there's not a sufficient connection, then the protest will be shifted over to the district court eventually under APA review. So in my paper, I tried to address this and propose some solutions. My solution, as you will see, is for the courts to address this by announcing a workable jurisdictional standard. And the standard that I propose is what I call a material nexus standard, which is a broad, flexible standard that a court can apply. So are there fixes? Yes. The first one is, if this case resource conservation group is overturned, this could potentially moot the issue, and then we'll be back at square one to figure out what exactly are the bounds of the Tucker Act bid protest jurisdiction. The second solution, Congress can definitely act. It could legislate and pass a statute that provides one of these two forms with exclusive jurisdiction. It could even provide both with concurrent jurisdiction if it so chooses. And then the third option, which is what I think, which is what my paper focuses on, is that there's a more immediate way forward, which is that courts can take care of this problem by just announcing a standard. So when looking at jurisdictional standards, there are certain goals that courts keep in mind. They want the standard to be clear. They want to provide litigants and courts a reasonable amount of foreseeability as to when a claim falls within a court's jurisdiction. The second one, it has to be easily administered, and that goes hand in hand with clarity. We want litigants and courts, but primarily litigants, to be able to understand when a claim belongs in court X or court Y without having to engage in litigation to fight over it or to engage in substantial discovery. And another goal that courts keep in mind is creating a standard that goes or supports the purpose of the underlying statute. So for example, in securities fraud litigation, there's an in connection with requirement in that statute. Courts have been known to apply it broadly because the purpose of that statute is to protect investors. So by having a broad standard for that requirement, more claims are able to be filed in court, allowing these claims of fraudulent conduct to be litigated. So these are just things that courts should generally keep in mind, and they do. Now, in the context of the Tucker Act, and after looking at this issue and looking at different ways courts have done it, I came up with 3 general buckets of standards that courts have applied. The first one I label as a stringent standard, which is a very heightened standard that requires a very close relationship between 2 events. The middle ground is what I dub a material nexus standard. And then in these situations, courts have required a material substantial connection between 2 events. Still, it's broad and it's less stringent than anything on the causality side. And then the last bucket is a tenuous nexus standard, which are standards that allow for very broad connection. For example, in this, again, in securities fraud litigation, some courts have adopted a touch upon test that the fraud merely touch upon the sale of a security. So of these three buckets, I took a step back and thought about keeping in mind those goals, which would make the most sense for section 1491B1 of the Tucker Act. And my recommendation would be the material nexus standard, the one in the middle. And to just kind of put some meat on this recommendation, here are some examples of how that would look like. So we'll start with stringent. If a court requires a stringent nexus between a prototype OT agreement and a procurement, meaning it's a very heightened standard, it would look something like what the court did in SpaceX, that the prototype OT agreement's outcome determinative or a necessary condition to the procurement. So for example, only prototype agreements, OT agreements that require a bidder to win the prototype OT agreement in order to compete for later procurement would fall within the Court of Federal Claims jurisdiction, and all the other types would fall within the realm of the district court, even those that have some type of logical connection. Under the material nexus standard, once again, this is a broader standard, I would propose that a court adopt something similar to this, which has two elements to it, a temporal and a beneficial factor, that at the time the agency competed the prototype OT agreement, the agency had planned for or was actively planning a subsequent procurement, the temporal aspect, and that the award of a prototype OT agreement would benefit the contractor in the subsequent competition for a procurement contract. So there's some type of beneficial aspect to it. So for example, prototype OT agreements that are part of larger programs, so that the agency hasn't necessarily, they have had planned or are considering a procurement, but not necessarily actively procuring the product in real time. And the prototype agreement itself is designed to help the winners of these agreements later down the road. Those types of agreements, like the SpaceX prototype agreement, actually would fall within the Court of Federal Claims jurisdiction. Last but not least, if a court were to adopt a tenuous standard, this is the broadest type. I would argue most of the protests regarding prototype OT agreements would fall within the Court of Federal Claims jurisdiction. So even if a procurement never materializes following the prototype OT agreement, it could technically still come within the Court of Federal Claims jurisdiction because there's some factual connection between the two. So results, pros and cons. So again, if a court were to adopt a stringent standard, the result would likely be that most of these types of protests would go to the district court. If a court were to adopt a material standard, many, but not all, would remain at the Court of Federal Claims, and then a tenuous standard, most, but if not all, would remain at the Court of Federal Claims. And there's very pros and cons to these types of standards, but once again, I would argue that the material standard is the way forward. It provides sufficient clarity. It's a workable standard. It supports the purpose of the Tucker Act, which is to consolidate procurement-related protests in the Court of Federal Claims, and it provides trial judges with a certain level of flexibility. Contrast this with the stringent standard. There is some clarity that could be provided with the standard, but at the end of the day, it's a heightened standard. It would go against the purpose of the Tucker Act. It would lead to likely a split in jurisdiction, which would lead to inefficiencies in litigation. And then the tenuous standard could be a good second place option. It provides clarity, given its breadth. It supports the purpose of the Tucker Act in that sense, because most of these protests would be coming to the court. But there is a risk that it could be over-inclusive and could lead to protests falling within the Court of Federal Claims jurisdiction that wouldn't logically or reasonably have a connection to a procurement. So with that, I think courts can take care of this issue. They just need to articulate a standard and abandon the ad hoc approach that these trial courts have been doing. A case-by-case analysis doesn't provide foreseeability to litigants in terms of knowing when a protest would fall within the Court of Federal Claims jurisdiction. And the preferable standard, in my mind, would be the material nexus approach, which is a broad, flexible approach that should still provide sufficient clarity and provide hopefully it would empower the trial court judges to administer it with a certain level of flexibility. I think that's it. So with that, I would love, to have any questions that you all may have.
How does this work vis-a-vis the people who are online?
So hypothetically, Professor Eukins is managing the chat log if there's electronic questions, which we can't actually see.
Yeah, that's why I.
And so we're going to let Chris moderate, but if you have a question, by all means, why don't you go ahead?
So, I had a question, Joshua Schwartz. I loved your paper. I think it's very important. Strike me with your three options that either of the two extremes gives you more clarity with respect to having a wall between the district court and the Court of Federal Claims. So if that was your desiderata, you'd want one of the extremes, but for almost every other reason, you'd want to go in the middle for the reasons you've stated. So I suppose part of the answer to that might be transfer provisions. So can you tell me about that? Can cases be transferred both ways? If somebody's not sure where to file and they file in the wrong.
Yeah, so, okay, to answer your first part of your question, the transfer provisions, yes, I mean, parties can move to transfer in these cases. That's what happened in SpaceX. So the Court of Federal Claims judge found that there wasn't jurisdiction in the Court of Federal Claims, and the parties moved to transfer to CDCal, and the case was transferred and it actually proceeded to the merits. So, logically, the same thing could happen if a case is filed in district court and the judge there believes that it's not appropriately,
That makes it more acceptable to have a somewhat, this intermediate standard will get clearer. And you build up a body of case law, but that'll take some time. Anyway, I cede the floor to Chris Eukins and his gang.
And just to your point about the middle option being the least clear, in a way it is, because, I hear your point. What is material, right? But if a court were to adopt workable factors underneath that material standard, so in this case, I propose a temporal and beneficial, factor analysis, that would bring, again, more clarity back into that. So it would provide concrete boundaries to that. There's ways to define materiality, and then the judges, the Federal Circuit may completely disagree with needing a temporal beneficial factor, but analysis. But the point is, there could be hybrids to these types of standards. So
Thank you. See you there.
Chris.
Oh, Chris?
Victoria. So we have a few questions from Sandeep Verma, an outstanding alumnus of the program. He's in India, and I always enjoy questions from Sandeep because they always help clarify things. So the first question, Victoria, I'm going to read very slowly because it's a little bit complicated, and what he's really, I think what Sandeep is getting at is a better understanding of the difference between the two phases, the prototype versus production. So his question is, so in a sense, procurement of a good or service or construction is equal to procurement, but procurement of a prototype is not equal to procurement. How and where to find a definition of procurement then?
That's a great question. So I think there is some overlap. I think, but first, where to find the definition of procurement? Our courts, at least in the Federal Circuit, have looked to certain statutes that have defined what a procurement is. The Federal Contract and Cooperative Agreement Grant Act, I believe, if I said it right, provides a definition of procurement that courts have adopted. So, and that's a little bit more limited. So there are statutes out there that define this term, but in a more general sense, a procurement in a more natural sense would be the acquisition of goods and services, right? And I think there is a danger of prototypes, OT agreements, or OT agreements in general, doing exactly that. And so that concern is valid, and there are ways that bidders have challenged that. I think agencies have in the past overstepped their OT authority and have tried to use that agreement to acquire goods and services through that agreement and not a procurement contract. And there's been protest lodged at the Government Accountability Office, flagging that, and agencies have been reminded that you cannot use an OT agreement for acquisition of goods and services. So there's a concern that requires, I think, if anything, that's a reason why protests should be coming through the system to make sure agencies aren't overstepping their bounds.
Thanks very much, Victoria. So Sandeep's second question is, would not every agreement for prototype eventually lead to acquisition of some good or service based on the prototype in the near future, except for random betting?
So I think the answer is no, for one, because I think practically maybe that is what's happening, but in theory, a prototype project could fail. It could result in a product that is not workable, or the technology isn't feasible, and so it never materializes past that point, and there is no procurement of the product because there's no product that is available. So in those instances, the agencies return back to the research phase and restart their efforts.
And the last question from Sandeep is, would not every prototype OT agreement holder always be in a better position, be it LPTA or competitive negotiations, to get better standing and evaluation of her bid for the subsequent procurement of an advanced modified version of prototyping outcomes?
So if I understood the question correctly, if bidders in a prototype OT agreement competition would benefit from competition or from negotiation, is that the question? No. Can you rephrase it, please?
Sure. I think what he's getting at is whether or not because these prototype, the companies that worked on the prototype stage would be in a better position in the follow-on competition. Shouldn't there be, I think what he's asking is, shouldn't we be leaning towards giving them a normal bid protest forum so that we can resolve issues in that procurement?
Oh, yes, in that sense, yes. I think given, and once again, it's not necessarily given that a prototype OT agreement leads directly to procurement, but I think definitely the theory behind it is that these are setting up companies to be in a better position to compete down the road. So I think there's going to be substantial connection in a lot of these prototype OT agreement competitions with the procurement. And in that sense, yes, we need a protest forum to make sure that what the agency is doing during these competitions is fair, transparent, and because if not, then we kind of miss the boat when it comes time for the object, or excuse me, the product or service to be procured. It's moot at that point, these errors. So.
Oh, perfect. I'm going to ask Steve Schooner to present a question from another alumnus, from Craig Barrett.
Okay, so first, one quick comment for Sandeep. One thing that may not be inherently obvious is remember that many prototype contracts are competitive. So we actually like the idea of what we often call the fly-off. So two prototypes competing for going forward. And at that point, the option would be either one contract or no contract. So the prototype regime is slightly more complex than maybe envisioned. But to Craig Barrett's question, which I think is an important one, on the one hand, he asks, is there an advantage to the protester for selecting the district court or the Court of Federal Claims? But rather than just take that by itself, I'm going to broaden it a little bit and ask you the policy question. So in terms of your advice, do you think that the correct result generally for the system should be that all protests should go to the district courts, all protests should go to the Court of Federal Claims, they should go to both or neither, and what's the policy? So first, from the protester standpoint, what would they like? And then what should the system actually, how would the system most benefit?
Right, okay. So I think for protesters, well, I'll acknowledge there is a debate. There was at one point concurrent jurisdiction between district courts and the Court of Federal Claims for bid protest in general. And when that ended, there was a debate, and I think some people were still arguing for concurrent jurisdiction for many reasons. That here at the Court of Federal Claims, there might be some type of bias or home turf advantage that trial court judges around the country and federal district courts can provide maybe a more unbiased view. So there are merits to both sides. I think based on my experience at the court and the cases I've looked into, the Court of Federal Claims would be the best forum for these types of protests. One, let's just look at SpaceX. So in SpaceX, it came to the Court of Federal Claims first. It didn't get very far. Within 3 months, the court determined there's no jurisdiction, dismissed the case on that ground, and then transferred it to the CDCal. That case sat at the district court for a year before a decision was issued. There could have been reasons beyond the public record why that was, but a year to get a decision on the merits of a protest is definitely an outlier. And when you look at the dockets between these types of courts, you can see maybe why it took them a long time. They have a criminal docket, they have a civil docket with thousands of cases, and Court of Federal Claims judges are busy, but they're not as busy as those judges. So, and they have the experience in the procurement world. They know the timeliness concerns of a protest. So when these cases are filed before the court, generally they are timely, provided timely review. So I guess to sum up, I would argue that the Court of Federal Claims is the proper, not only a proper forum, but should be the sole forum for this. That said, what is the best for the system? Once again, I would say that's the best for the system. And then short of that, I would say I'm indifferent between concurrent jurisdiction or sole district court jurisdiction. But what we do need at the end of the day is a clear answer. That's what we need at the bottom of all this, is at least giving litigants notice where to file. That's better than what we are right now, where there's some clarity, because as most judges would say, litigating a threshold issue like jurisdiction is a waste of resources and should be better applied to the merits of the case. So.
Thanks, Victoria. So we have a question from a real superstar in the OTA world, Andrew Bound, and I'll read his question for him. I'm delighted he could join us. He asks, would the existence of notice under subsection F for a potential follow-on production OT or procurement contract during initial competition for the prototype OT be sufficient nexus in your proposed approach?
Yeah, definitely. That would be a sufficient nexus under any of the 3 standards. It would definitely meet the tenuous, which is the most broad material, and the heightened standard, because in my mind, the heightened standard, it requires some type of direct causation or outcome determinative link. So if there is notice put out by the agency that following this prototype OT agreement, we're going to move into production, then that prototype OT agreement is directly connected to that procurement down the road. So it would meet, to answer your question, any one of the nexus standards. Yes.
Ken Sachs, LLM student in government procurement. The question of, since COFC judges' decisions are not binding on each other, and the amount of time that it takes to get consensus being COFC judges, if you can get it, and then the need to go to CAFC to get that consensus, what about the idea of simply getting an amendment to the Tucker Act that clarifies this question?
You know, I think you're right. The way you clarified it, or presented it, it's litigation takes time. Appeals take time, especially in this environment, government procurement, where appeals aren't filed very often in this I don't really have an answer. What would be quicker, to get the legislative amendment or going through the court process? I think, I would think the court process, there's an option that it could be quicker because all it takes is one protest being filed. That protest being filed, the court dismisses it, the parties appeal, and there you go. You have an immediate option at least. And the control remains with the parties filing the protests. So, so that's why I tend to lean more towards thinking that it would be faster through the court system. Yes. Oh, Chris, do you have a question?
I have one.
And Josh has one too, Professor Schwartz.
Please, Joshua first, and then I'll follow up.
It's actually built off something that Sandeep said. I remember him warmly as well. It may be true that in many cases, some fail, but many OTAs will lead to a procurement. But in judging the in-connection standard, am I right in saying that it can't possibly depend on what happens, ultimately happens, because what ultimately happens may happen later, so that the protest on the OT is happening at a time when we don't know whether there'll be a procurement. Even if one was intended, it might fail. So you have to have a standard that can be applied either on the facts on the ground that exist, or maybe what's planned, a reference to, I'm sorry, I forgot who did it, said it, but if you have a built-in clause for future production. But it can't depend on whether there ultimately is a procurement, right?
Right, no, you're correct on that. It doesn't depend on whether there is ultimately procurement. I think it depends on whether at the time the prototype OT agreement competition is taking place, we look to what the agency is doing. Have they already planned for a procurement? Great, that becomes clear. Or is there one in the works or one foreseeable? I think what would definitely not be enough to have a connection is they have their focus on a prototype OT competition and there's no planning, no discussion about a future procurement. And it may be because the technology is so iffy. They're concerned that there's very little likelihood, but they still want to take a stab at it. So.
But if I'm hearing you right, so like a lot of other places in law, the standard is basically one of foreseeability.
Mhm.
And sometimes it's hard to foresee, but that's still a standard, whether or not it's easy to apply.
Right.
Can I follow up with one other on Sandy? The other thing he said, one who, if there's only one, Steve clarified this point, if there's only one prototype contract awarded, and then they're successful, Sandy said, well, as a practical matter, they're going to have an inside track on any follow-on procurement. I'm wondering how we draw the line between that, just sort of a fact, and what our old friend Dan Gordon would call an organizational conflict of interest.
Right.
Why isn't this in those? I gather it can't, because otherwise the prototyping process wouldn't work. We disqualify the people who knew what they were doing.
Yeah, I mean, I think there's accountability and transparency concerns, and that's one of them. And but to take a step back, why?
I know this is outside the scope of your paper.
No, right.
Sandy is right that it's out there.
It's out there, and I think that should be added to the list of concerns stemming from OT agreements in general. But for purposes of a jurisdictional analysis, it seems based on the SpaceX judge's reasoning that so long as so if there is one prototype OT agreement awarded and if there's a procurement down the road, as long as that procurement is technically open to anyone, then there is no concern because anyone can show up and still have, technically a chance of winning. Practically, no, I don't think so. I mean, look at SpaceX. The three winners got between $500 million and almost $1 billion in investment to produce these prototype agreements. But the court still said that SpaceX still had an opportunity to compete down the road. So that prototype OT agreement wasn't connected to a procurement. So at least under a jurisdictional analysis, what we have right now is courts tending not to care, I guess, about that, which is troubling because in practice and in substance, that seems very limiting. If you don't win the prototype OT agreement, you're likely not going to win the procurement contract. So, you know. Chris, do you have any questions? Any other questions?
Yeah, I had a comment and then a question. So the comment is that we're doing a bid protest study of bid protests at DoD, and the consensus position that's rapidly emerging is that bid protests are really best viewed, at least from the department standpoint, they're best viewed as whistleblower mechanisms. And if that's the case, a whistleblower needs to go to a forum that's well educated. That certainly weighs in favor of the Court of Federal Claims, if you look at it from that perspective. The question I had for you is, you talked about a possible legislative change, Victoria. A lot goes on in this area. A lot of it goes on in this field by language that's included in the conference report with the National Defense Authorization Act. Rather than an actual statutory change, do you think that there could be clarification in a conference report with the National Defense Authorization Act that resolves this issue?
I think so. I'm obviously aware of the Authorization Acts, and so to the extent any clarification that's provided in that becomes part of a binding law, then I think that would suffice. We wouldn't need a whole other statute or amendment to the Tucker Act. So I guess it depends on the binding nature of the clarification.
It's actually what the patterns emerged over the last few years is that it's not uncommon for the conference report to cross-refer to academic studies and applaud those academic studies as a signal to the bodies, let's say in this case, a court. I think that might be a useful first step.
Yep, that's a great point.
Okay. Steve Schooner, I think, has a question or two.
Yeah, so it is my nature to be cynical, and I don't want to be overly cynical, but one might point out that the whole point of other transactions, if we go all the way back to Paul Demling, an alum of the law school, who was the general counsel both at GAO and at NASA, he kind of came up with this concept when they were creating NASA in the original authorizing statute. And if the whole point of other transactions was to remove these contractual arrangements from now the FAR, Federal Acquisition Regulation, or of course the predecessor regulations, if the original point was to remove these contracts from the regulatory process, maybe the point should also be that we should be trying to avoid protests or challenges. So maybe to be true to the goal of OTs, we should be trying to limit protests or make it as difficult as possible or as confusing as possible to protest. So where am I off base in terms of that policy argument?
Yeah. No, I hear you, and cynical keyword. That's great. I think there needs to be a distinction between streamlined, efficient contracting processes, which OT agreements are aimed to provide, and accountability, transparency, and responsible use of taxpayer funds. That distinction cannot be forgotten, especially with the high monetary value of these types of agreements, millions of dollars, almost $1 billion one type of agreement. So given the importance of that taxpayer money is at play, and that these OT agreements, by and large, in a practical sense, do have great impact on procurements, there needs to be a channel of accountability open. And there's different ways of doing that, but I believe the bid protest system is a very efficient way to do that for various reasons. One, it is litigation, so that takes time, but we have forums that provide review in a timely manner. And two, at least in the at the Court of Federal Claims, it's very deferential standard. Courts are not in the business of double guessing these important technical discretionary decisions that agencies are making. So if anything, they're providing a high level check to make sure that nothing arbitrary or capricious or illegal is going on. And that can only, in the long run, benefit not only the government, bidders who have faith in our system and want to do business with the government, and the public. So
I think Chris has at least one more online question.
Actually, I now I have two. The first one's, I think, from Matt Ryan. He asks, does it perhaps depend practically on the agency obtaining the technical data software license rights that enables future competition?
Well, I think, and I guess maybe clarity would be future competition, allowing the agency to actually engage in a procurement down the road. Is that what that question's getting to?
I think so. I think he's asking whether or not you have a sufficient nexus if the agency obtains the technical data or software license right that will enable that future competition.
Oh, I see. I think that there's a case being made that definitely is some connection. So now the question becomes, under which standard, and is it enough? So definitely a connection. So under a tenuous connection, it's going to be, enough. And I would argue that that is material in a way. So it would pass the material nexus standard. And it becomes a little bit more questionable under the stringent standard. But yes, definitely a connection.
We got a question from Kate Borzeris, a really interesting question. And because I'm not sure how this cuts. Her question is, OTs are also aimed to bring in non-traditional contractors who may be much less savvy at navigating the bid protest system. How does that fact play out?
In terms of impact, it's a relevant point, but I don't think it would impact any type of jurisdictional analysis at play. Their familiarity with our bid protest system would hopefully come with time, because it's a good thing for them to be able to bring a protest. So long as they have a non-frivolous claim that there was some type of arbitrary action. So it works to their benefit to get up to speed. So to the extent that we're concerned that people don't know how the system works, so we shouldn't clarify the system much. I think it's counterproductive. We should definitely clarify the system and provide that clarity, especially for these people who are new to the system and are trying to figure things out. So.
Matt had a follow-up, and I think it's more of a comment, but it does play into your, as you think about your paper and how you present this. He said, I think if OTA's focus is on obtaining technical data rights, it would support the policy goals of accessing advanced technology while protecting the ability to obtain competition. So I think he's saying that if the nexus comes from getting technical data rights, and the focus then is on getting the technical data rights, that actually advances the purpose of OTs, which is to access innovative technology.
I see the logic there. Yep. So yeah, I would agree. Sorry. Is there a question?
No, I think it's a good comment. I think it was a very helpful comment from Matt. So I don't have any more questions. Let me just check the Q&A here. One more. Nope, we're all set. We have no more questions in the Q&A. We have a closing comment from Sandeep. You'll have that in the chat. So thank you very much from here, Victoria.
Okay,
So,
thank you.
So let me also suggest that if you're with us, I'm confident that Professor Christoff would love to have any comments that you want to communicate to her directly by email. There is already an updated version of the draft. And of course, she may be willing to share the draft with you as well. But again, thanks so much for joining us today. And hopefully we'll do more events like this in the future.
Yeah. Thank you, everyone.
Thank you, Victoria. Bye-bye.